This year I choose to be a faithful steward.
This year I choose to be a faithful steward.
Stewardship means the careful management of everything entrusted under one's care.
Do you know your talent? Do you know what purpose you are created for? You are created to serve God and to serve fellow men with your gifts and your talents.
Know ye not that your body is the temple of the Holy Ghost, which is in you, which ye have of God, and ye are not your own? For ye are bought with a price, therefore glorify God in your body and in your spirit, which are God.
There is a purpose and a season and a time for everything under the sun. Time is the universal standard that will be used in judging everyone under the sun. No one can say they were given less than 24 hours.
I will honor the Lord with all my substance and also with the first fruit of all my increase.
I choose to be a faithful steward of the Sabbath. Just as tithe is holy, so is it the Sabbath. God sanctified it and made it holy.
I purpose to be a good steward of my body. I pray you do.
I purposely choose to be a faithful steward of finances.
This year, I choose to use my talent to glorify God.
I choose to be a faithful steward of time.
I choose to be a faithful steward.
We choose to be faithful stewards.
I choose to be a faithful steward.
I choose to be a faithful steward.
My brother, what do you choose to be?
I choose to be a faithful steward.
I also choose to be a faithful steward.
Softly and tenderly Jesus is calling, calling for you and for me.
Who are lawyers? All lawyers in the house, so that church you can know them and you can actually, if you want follow-ups, and to ask further questions, you can always see them. Lawyers in the house, please stand, those who are in the congregation, and just wave. That is Nancy, and that is Anne Kamau. Kerubo has just walked out, and I know others are coming in. Sound, please adjust this again. Check, check. Yeah, I think that is okay. It can stay that way. Church, let me reintroduce the people that I introduced in the morning so that we start. On my left, we have one of our own, a Gloryland, but a professional. Dorcas, do you want us to move this so that you can see clearly, or you are okay? All right, all right. We have Brian Otieno. He's a strong lawyer and a member of the Seventh-day Adventist Church, Gloryland congregation. And Brian works with a law firm called Bowman's. It used to be called Coulson and Honey Advocates, but they changed their names and because of cross-border collaborations. Headquartered, I think, in South Africa. He is one of the leading regional law firms. And Brian is handling law of taxations, tax law. And you will see this afternoon the interrelation between tax law and the succession and estate planning that we are going to talk about. There is an interface, an interplay between the two, and how depending on how you structure your estate or your property within the family, how tax is likely to affect your property, And how is it that how can we advise you and help you as a church, help each other to make sure that wealth is preserved and is not lost in taxation? You know that tax evasion is an offense, but tax avoidance is not an offense. You understand that, church? Huh? We are together, church? Tax evasion is what? But tax avoidance? Yeah. So one is someone is a trickster, another one someone is wise. Are we not wise? Well, so Brian will be taking us through. Brian, would you say hello to the church?
Good afternoon.
Brian will also present the biblical foundations of will writing and succession and inheritance from biblical perspectives. I have on my right Grace Mokeira Kambuni. She works for Kaplan and Stratton. She's a, let me say loosely, she's a company law expert, but a governance, corporate governance expert, a trainer of many boards, leading boards, including East African Development Bank and others. Let me mention the clients she works for, because some things are confidential, but we are not here to talk about our clients. We are here to help the church. Now, alongside that, she has a deep interest and has practiced in that area and experienced through clients the challenges they go through if estates or family property or family wealth is not well planned, or there is no succession plan in place that is elaborate enough to be able to take care of a family. So she will be taking us through those areas. How many welcome Grace Kambuni? Grace, would you say hello to the church?
Good afternoon. Welcome to the discussion, and I hope will be helpful.
Amen. So, and Dismas Ndege, I will be moderating this afternoon, just so that this discussion can take a good sense of direction and we can achieve the most out of it. Now, we will give Brian 10 minutes to give us biblical foundations, and then we will give Grace Kambuni 10 minutes to give us an overview of the areas she's presenting. Those are 20 minutes. And then we will have them both, because issues will arise out of the presentations of each other, to just do 5-minute clarifications. That will take us like 30 minutes. And as they do that, as they do their presentations, I hope you have a pen and a paper. If you have questions or areas of concern or clarifications, please feel free to write them down and pass them, because after the 30 minutes, we will allow another 20 minutes of question and answer, and then we'll have a wrap-up at the end of 10 minutes. So we hope to have 1 solid hour of very meaningful discussion and interaction. I don't know, what time is it now? Because in the professional field, I'm very strict, so we shall keep time. So it's 2:40. So by 3:40, 3:45, we should have finished this so that you have a breather for 10 minutes before we start the other program at 10 o'clock. At 4 o'clock. Are we together, church? Amen. So I'll start with Brian. Your 10 minutes start now, Brian. Please do an overview of the Bible and the foundations for what we are talking about: inheritance, succession, and will writing.
All right. Thank you so much, Elder, for the generous introduction. I will not repeat my name. I will go straight into the subject, whether there is a biblical foundation to the matter's succession. And the answer is yes. There is a biblical foundation to matter's succession. Now, as you know, there are two things that are certain to happen in this world. One of them is what? Death. And the second one is what? Taxes. And Solomon will put it in the book of, I believe it's Ecclesiastes chapter 9, verse 2 to 3, that all of us are moving towards death, whether you are righteous or wicked, whether you are good or bad. whether you are sacrificing or not, all of us are headed towards what? Towards death. And so that calls a question, what then should we do in preparation for this? Well, let me put a caveat here and say that we're not telling you to die. We are not telling you to preempt your death. But because it is certain that at some point in your life you will die, it is important to put your house in order. As Hezekiah will tell, as Isaiah will tell King Hezekiah, if you read the book of 2 Kings chapter 20, King Hezekiah was sick, and then God tells Isaiah to go and tell Hezekiah to put his house in order because he will not die. And so you can expect, or you can try to imagine, what did the Bible mean, or what did Isaiah mean when he told King Hezekiah to put his house in what? In order. It had to do with something about preparing for transition as a king, but also in his personal capacity, it was putting his house in order. Remember, the Bible uses the first person. It says, put your house, not my house, in order. So what does it mean, or what does it take to put your house in order? It has something to do with organizing your estate, ensuring that everything that you own has a proper channel of distribution from yourself to the next person. Yeah? And that is why the Bible has specific provisions and examples of people who organized and ensure that they organize the property and estates so that those who came after did not just inherit the property itself, but even the business that was part of their estate. I hope I'm not using strong terms here. I'm starting to see people looking at me with interesting views. Estate basically refers to all property that you own. So it could be real property, that is land and buildings. It could be personal property, yeah, your own clothing. It could be movable property, your car and all that stuff. So putting all this together, that forms the estate. Yes, that's personal property.
Nelly is concerned if shoes are included.
Yes, it includes shoes. So that is what happens. So the Bible has foundations and biblical provisions that talk about putting your house in order and ensuring that you have a will. And I will read one Bible verse, and that is the book of Hebrews chapter 9, the book of Hebrews 9, and verse 16 and 17. Now, this talks about, this calls a will a testament. The verse I'm about to read is calling the will a testament. So verse 15 says, and for this cause he is a mediator of the New Testament, that by means of death, for the redemption of transgression that were under the first testament, that they which are called might receive the promise of eternal inheritance. 16 says this, and I want you to listen keenly. For where a testament is, there must also of necessity be death of the testator. Do you get the point? So it talks about a testament, and then it says that for that testament to become effective, then there must be what? Death of the testator. And we will define these terms. I hope you are still with me. Verse 17 says, for a testament is of force after men are dead. Okay? A testament is of force after men are dead. Otherwise, it is of no strength at all while the testator lives. So let me say that again. For a testament is of force after men are dead. Otherwise, it is of no strength at all while the testator lives. So this is talking about a testament that comes into force when the testator dies. Now, let me make this simple so that we sail together. A testator is the person who writes a will. It is the person who owns the property, owns the assets, and he wants to pass them down to a child, to a spouse, to someone who is depending on him. And so he makes a testament, what is called a testament here, which we will call a will. So this will shall have everything to do with how he wishes that his estate, all the property that forms part of the estate, whether it be real property, personal property, movable property, immovable property, everything else that forms part of the estate or that he owns, yeah? He wishes that it should be dealt with in a particular way after his demise. So what he will do is, he will sit down and write a will that then will ensure that he knows how the property will be managed after his demise. He's ensuring that he knows who will own the property after his demise, and that nothing that he owns shall be wasted or spent, like the prodigal son will do, ask his father for his portion of the inheritance, and then goes to a far place, a far country, and all of us know what he did, right? What did the prodigal son do? He went away and he squandered, that which his father had given him. But of course, that was during the life of his father. But this may be the fate of some of us in this house or in this church today, if we fail to put our houses in order in a way that we can take control and ensure that the property we own shall not just pass to the children or to our spouses, but to the children's children and to generations to come. Because as the book of Proverbs put it, that a good man, leaves inheritance for his children's what? Children. So it isn't just about you yourself and your immediate family members, wife or children or husband or otherwise, but it is ensuring that the property succeeds you, it succeeds your child, and it succeeds your child's child. Okay? So in the context of today's discussion, and as I finish, we're going to look at how do we ensure that we preserve our estates and take control of how the property that we own shall be managed by those who come after us. That is the essence of today's discussion, and the Bible, as we said, makes provision for the fact that we can make wills which then become in force after we are dead. Yes. Thank you.
Thank you very much. How many have liked that first part? The Bible says that the dead know nothing, but how can we continue to speak after we are dead? Even in law, there is a maxim, let me now sound legal today, there's a maxim that says, actio personalis murturcum personam. In other words, an action dies with a person. I'm not saying anything big. An action does what? Dies with a person. But then, how can we determine what happens to that which we have worked so hard for? But apart from that, it's not just after you die. Our sister, Grace Commune, is going to take us through how can you begin to train, and how can what you are making and doing have effect when you are alive and after you go. Yeah? So Grace, take us through estate planning and aspects related to it. Thank you. How many welcome Grace? Tumpigie makofi kidogo. Yeah. Thank you.
Good afternoon once again. First, I'll start to mention that anytime we mention about succession, we all of us frown and think that we are thinking about your death. We are trying to plan your death in advance, and I think this is one of the things we need to move away from. As people who are fully aware that we have different stages in life that we all have to go through, we need to make certain decisions, and these decisions, we need to make them during our lifetime, so that these decisions that we make are able to be implemented even when we are deceased. I will be covering specifically what we call family trusts. This is a mechanism of managing your property during your lifetime. And in saying family trusts or a private trust, I'll be focusing mainly in such a way that you have properties. Sorry, I'm struggling with the mic a bit. When we say family trusts, one will be thinking of private trusts. You have a business or you have properties, and you want to see how do my properties get managed even when I'm still alive. And how do I protect my properties just in case I go bankrupt, my properties are not sold to pay the debts. The protection that you are able to enjoy when you form this, what we call family trusts, is that once you transfer the properties to the family trusts, then they cannot be sold to pay your family debts or the debts that you have accrued during your lifetime in case of your demise. And this is some of the things that we are trying to encourage anyone who owns property or who runs a business as a way of protecting your property and ensuring that you are creating more wealth for the generations and generations to come. One of the things I will actually be focusing also is on family-owned businesses. as parents, you always say, you know, niko na kile kiosk. Let me put it in the terms that we understand. You have a kiosk somewhere. And when you have this kiosk, unasema daddy na mami, your children now, their work is to study. But you is generating the revenue, this revenue that you're using to educate these children, you do not want them to understand the process of generating this revenue. And when you do not do this, your children, there's a likelihood of that business not growing in case of your demise or in case of you being incapacitated. One of the things as part of succession planning or estate planning is to try and see if you can introduce your children who have, maybe we call it the business acumen, or the children who have the capabilities of running your business. How do you introduce them to the business to ensure that the succession of that business and the business growing from one generation to the next? We have very live examples, and since I'll not be accused of anything, since the information is in public domain, we have seen the example. I will use an example of Tuskys. This was a family-owned business, but because of lack of proper succession planning, we have seen the business was not able to survive beyond the founder, who was the mzee. Now the children came on board, they were not able to run the business efficiently and effectively. And that led to the demise of, led to the close down of the business of Tuskys. Now, when we speak about this, most of us, and this affects us as a church, as the middle income earners, and also, you know, we can be, you know, we have also actualized in life, but we want our children to be shielded from the activities that we do to generate revenue for their own good. And if you look at the Asian community, I'll give an example of the Asian community. You'll see business which has survived generations and generations. And how this business has been able to survive is because of how they are planned their business and how they have done what we call estate planning or planning of the family business. Now, when I say this, most parents will be asking, will I introduce my 1-year-old, my 2-year-old to the business? Will I be introducing my high school child to the business? I'll say no. There comes a time that your children need to understand what you do to generate revenue. And if you're a business owner, make a point of your children appreciating the effort that you put to derive revenue. And when your children appreciate this, and you start introducing them slowly, and one of the things, the reason why I say introducing them slowly, if they are able, you are able, as parents we know, you know your children. Kuna ule unasema huyu nikimpatia hii pesa atakula yote. Na kuna huyu nikimpatia ataeka zingine na they will be able to save for tomorrow. In that way, you are able to plan for tomorrow, and you're able to ensure that your business is able to be succeeded from generation to generation. When you move away from now introducing your children to the business, how else can you be able to ensure that the success of your business continues? Now, this is where now we bring in the family trusts or private trusts in better terms. The trusts can run your business or can hold your property during your lifetime. And this can be able to run the business, and you can be monitoring. During your lifetime, you're able to see, how is my business being run? I've entrusted this business in the hands of Nancy and Dandege. These are the people that I've appointed as trustees of my business. How are these people running my business? If I was to be incapacitated today, are my children assured that the business can be able to derive revenue, that can they be able to benefit from this business? Or in terms of my properties that I own, these properties that I own, one of the protections that you enjoy when the property is is owned by the family trust, the children cannot dispose that property as they wish. Who are the beneficiaries? You can be, you are assured that these children at least are assured of enough adequate provision during their lifetime. So you are able to protect your wealth, and you are able to create more. I don't know whether I've missed anything, Brian, on terms of family trusts, but one of the things I will encourage that as parents and as Adventists, as a church as well, let's make deliberate decisions during our lifetime for the benefit of our future generations. There is something else that you will want to touch on in terms of succession. When we were discussing the issues of succession, my colleague Nancy here, there's something else we mentioned about even as you create these family trusts, there's an issue about intestate succession. Intestate succession, as I'll say it, is where someone dies without a will. You have died, you have not left a will, then what happens? What happens to your wealth? We have seen many issues. Even when there is a will, we have seen many issues in terms of property. But one of the things that we'll keep on encouraging, that as a way of planning your estate, ensure that you either have a will or you have created a trust. But in case there is none of this, if you feel you're not at a level of creating that, please create a record of all the assets that you own. And let this record be known by someone either close to you or a confidant, that you can be able now, someone who knows, if Nancy is not there, sorry Nancy, I will use it as an example, but if anything was to happen, this person can be able to identify certain assets that belong to Nancy, and then they can be able now to start taking necessary legal actions to attain what we call, when you die intestate without a will, you'll be obtaining letters of administration. But for you to qualify to get those letters of administration, I'll touch something on marriage. For those of us, we know all of us who are in the church, we may be staying in situationships, which may not be necessarily qualifying as marriages as per the law of marriage, which is the Marriage Act of 2014. If by any chance you are settled together and you have never formalized your marriage, we highly encourage that you formalize your marriage, because anyone who's defined as a husband or a wife will be defined by the Marriage Act as someone, you must have registered your marriage for you to qualify to be called a wife. So if you can't come, or you can't come to claim and say I'm a husband to this person, yet you do not have evidence of your union. And the evidence of your union will be a registration. I do not want to deny that there might be unique scenarios where someone might be a second wife, and maybe in the congregation. But even in this, ensure that necessary ceremonies have taken place to show that for sure, as per the African customary laws of marriage, you know that dowry has been paid, and people, to show evidence that for sure we have acquired, as the laws will say, we recognize you as our wife. For them, ensure that those ceremonies have taken place, so that even when you're laying claim on the estate, you have a legal basis for you to be able to lay claim on that estate. Intestate are very contentious matters. You waste a lot of time, and as lawyers, we are happy to assist you, but we don't want to assist you when you have a problem. We want to assist you before you get to that problem. So I'll encourage in the congregation, take necessary steps. If you feel that you can't make a will now, take the necessary steps to be able to put the records of all the assets that you own, and never say that I do not have much. Even that one property that you have somewhere, make someone be aware of the same. Because if you do not do that, someone else will derive a benefit out of that property who was not meant to derive a benefit out of it. I'll close my discussion at that point and hand it over to Brian to add if there's anything I could have left.
Yeah, as Brian comes in, when you say a record of properties, you just reminded me about a certain person I know. Sound people, please add some slight volume. Someone I know who was very senior in the country before and in government, and there are properties all over Kenya, and when he died, the children did not know so many of the properties that person owned. 10 years after his death, because when you do succession and you go to court and you finally get now intestate when there was no will, and you finally do a schedule of properties, and maybe the court now finally orders for partition or subdivision of property, you go so far, you settle, you come with the orders from the court, the registrars in the lands offices effect that. 10 years later, they discover they have 10 more properties or 15 more properties. After that process had been concluded, and you have to go again to court and appoint administrators and go through the process again of finding a way of owning or benefiting from the properties that the father of the home left behind. So something is coming out clearly that amongst those in the community that have a biggest problem with this are men. There are very many secrets. Men have very many secrets, so they will, I don't know why we think that our spouse does not qualify to know these things, but you will find that people who are not close to you and are far away from you outside there that you call friends are the ones who know what you own. Now, another person that I know was very senior and wealthy, I will not mention his name. He had more than one spouse, more than one wife. And when he was in critical condition in hospital and about to die, because they were just told we will unplug the machines, it's just about the life support that we are unplugging, and this person goes. Already, Grace was being consulted, without naming names, by one of the children of this party from one of the wives. And she was coming to say, the way he wrote that will, it's just that I respected him. I could not be able to tell him off, but just know that I need your advice on how to contest the will in court. So that what she was saying about estate planning and what she's talking about planning, when you know, there's a living trust, meaning that it is effected when you are alive, and there's that one that is effected when you are dead, is that do as much as possible, that's what I'm getting from Grace, when you are still alive, and when you can be able to put your children there of age and put them in the trust, and let them run the family business, when you can watch and train them. I was telling Elder Koech on the side before we came in, I told him, Elder, make sure you attend this because your children are above 18. This will be very critical to you. And the Asian communities that she mentioned about, that is why you see their companies last for ages, hundreds of years, because you don't give a lot of options to your children and their children on what exactly to do with the property subdivision, and someone starts selling and someone is doing their own things. And things that are in the public limelight that are already in the public domain, like Karume, Njenga Karume, like Kirema, and others who have had very many problems when they had very many properties and they did not plan in their lifetime. I don't know, it's something that we need to disabuse, we need to change and learn from as Seventh-day Adventists. And for us, our faith is in keeping with planning, isn't it, ladies and gentlemen? Yeah? Our faith is about planning our death, isn't it? It says so. Even the biggest inheritance being the kingdom of God. We are supposed to plan ahead of it, and God has told us about everything that will happen to the life after this life, isn't it? So it means it's something we should take cue from. And even in the Seventh-day Adventist Church, when you go to the website, you can read about trusts and wills, and from the Religious Liberties Department, there's a lot of information about trusts, but those are other kinds of trusts, like what we were trying to form earlier, to own property and all that. So trusts, as it's coming out, would be the safest as opposed to even wills, and we are now going to get the advantages through Brian, taxation advantages, problems that he has seen handling now, that other end of taxation. And just to say one is that right now, for properties, when you're selling properties now, the capital tax, capital CGT, capital gains tax, has changed. You know that, ladies and gentlemen? It was 5, but now it is what? 15%. So it is going higher and higher. I said, evading tax is an offense, but avoiding tax is what? Is wisdom. So let's see from the expert, because the surest things he said were 2, death and taxes. All right.
Yeah, thank you so much. So that we can look at the tax convenience of having a family trust and family companies. Basically, we can look at the tax implications of various vehicles, let me call them, or investment vehicles that we can have in companies, in families. So let me take that again. We're looking at the tax convenience of various investment vehicles that we can have in families. So we can have family trusts, we can have family companies. Let me start from that because that's the most prevalent. So you need to look at the taxes based on taxation of what goes into the family trust and what comes out of the family trust. You also look at taxation based on what goes into the family company and what comes out of the family company. Because if I am going to part with some amount as I transfer property from my name to my family company, or as I transfer property from my name to the family trust, then I need to look at alternatives to ensure that I don't incur any costs while I transfer money into and out of. Family trusts are the most convenient because they don't charge, they're tax exempt. Family trusts in themselves are tax exempt. You don't pay any corporation tax on family trusts. So if you own a family trust, you have got no headache of getting a consultant to ensure that you file your returns, ensure that you file your taxes and pay. You don't have that headache. When you transfer property from your name to a family trust, it is exempt from taxation. So there is no tax that you will pay as you transfer property from yourself to your family trust. When you use the money or investment in the family trust to solve problems, maybe buy a car for a beneficiary within, because the trusts have basically 3 parties, which I will define as follows. So there's the settler, who is creating the family trust. And then there is the trustee, who is supposed to oversee the affairs of that family trust. And then there's the beneficiary, who is supposed to gain, or who is supposed to benefit, from that family trust. And sometimes beneficiaries themselves could be trustees of that family trust. When you are paying expenses, maybe you want to buy a house for your child from investments that you have in a family trust, then it is exempt from tax up to 10 million. You can verify, but it is exempt from taxation up to 10 million. So that if I'm supposed to buy a house for my child from the investment that I have in a family trust, then I won't be required to pay capital gains tax for buying the house that my child will live in from a family trust. The same case applies when you're paying school fees for your child. As you take out money, you have that convenience. Now, why is the family trust preferred to a company? We said it is tax-free as property goes in, tax-free as property comes out, and in itself, there is no tax because you don't pay corporation tax. You have got no compliance obligations to file returns for the family trust. The other investment vehicle that we have is family companies, which means that I can have a company that is incorporated in the name of my name as the owner of the company, and then I have shares that are held by my spouse and my children and probably grandchildren. The challenge with that is that as the property goes in, you will only be exempt from taxation if yourself, your spouse, and children hold 100% of the shares that are in that company. So that if your grandchild has shares in that company and they're transferring property to that company, then you're not exempt. You'll be required to pay capital gains tax for transferring property from your name to your company. So that is the first limitation of having a family company as an investment vehicle for holding family properties. The second thing is that as money comes out of the investment vehicle, unlike in family trusts, you'll be required to pay taxation for the benefits that you get out of it. So if you're taking out dividends, you'll have that to confront. If you're taking out money to buy property, you'll have that to confront because there is no protection. And the company itself will be required to file compliance. You know, if it's a company that is, say, a limited liability company, then it has tax obligations. So it becomes more hectic, it becomes more cumbersome, and more costly because transferring property has a limitation to the extent that everyone who has shares or the 100% of the shareholding in the company is held by spouses and children only. So if it is your grandchild who wants property or you want to give them interest in the property, then that will be limited to that extent. So you can't have that exemption. So it is preferable from a tax perspective to have a family trust to hold your investment as opposed to family companies. And I think you will also hear issues about testamentary trusts, which then come into effect after you die. Because you create a will, and then in the will, you create a testamentary trust to ensure that the property is overseen. The challenge with that is that it comes into effect after your death. Compared to family trust where you are still alive, and you have the privilege of seeing who is handling the property, who is best talented to manage the property while I am alive, so that when you go, you still have the assurance that no one will misuse or squander the property that you have in your absence. So the long and short of this is that, or the summary of what I'm saying is that family trust, both from a tax perspective and even from a legal perspective, it is more preferable to have a family trust as an investment vehicle compared to testamentary trusts, compared to family companies and etc. Yeah.
Thank you very much. I will invite Grace to, I'm sure there are clarifications she will make. Then we'll open the floor for those who have questions. I know there are many questions. But are we, to this extent, clear enough? Are you understanding? Are you following? Are you following, ladies and gentlemen? Talk to your elder. Are you following? Okay. All right, so I'll invite Grace to say a few things for clarity. And Brian as well, I'll again give you 2-3 minutes to clarify, then we'll take it to the floor.
Yeah, Brian has mentioned about trustees who have been appointed by the CETRA or the person creating a trust. The question then one may ask themselves is, if I've appointed trustees and by any chance they're mismanaging my estate, what remedy do I have? We are lucky that there is someone else we call an enforcer. An enforcer is someone under the law who is recognized to oversee the activities being done by the trustees. This enforcer is literally monitoring what the trustees are doing. It's a new matter that has come up. Enforcer usually used to, it's really mostly in the Europe part. This is where it was really it was being applied. But now with the new amendments under the law, we have seen that being introduced as a way of also holding the trustees accountable. So you have someone who is independent of the trustees, who will now be seeing what the trustees will be doing, the activities, how the trustees are managing the estate. And one of the key things I'll keep emphasizing on it, as we do this, as we create the trust, the really advantage of this is that you are able to see how things are being done. And you can be able to change trustees. You can revoke their, the trustees can be removed at any given point. If you feel Grace is not serving my interest, during your lifetime, you can actually remove Grace as one of your trustees and appoint someone else to continue managing your estate. We'll keep on encouraging that. Never say that you wait until you accumulate so much for you to be able to put your estate in order. And even so, the other thing I will give a clarification is that even as you create a will, don't think that I have to wait for me to accumulate so much to create a will. You can keep on amending your will, and there's what we call a codicil. It's an amendment and a document which will be attached to the original will to show the amendments that you've made. And this comes on point where you are adding other properties, you are acquired other properties, you want also, you are in that, you are also saying you are even changing maybe a few things on distribution and everything. I keep on, I will say this, that let's encourage each other to plan ourselves, because failure to plan, you're planning to fail. Because even the property that you have worked so hard for, if you fail to plan and protect it, then actually you will be subjecting your property to waste. That will be my end. I'll hand it over to Elder.
Okay, thank you very much. Even as we move to Brian, that new concept of enforcer, I think, is very important, because I am advising a family now, personally, where their father was East Maasai. He died some time back and left a lot of properties all over. And then appointed, because here is my point, the people that you appoint as trustees, it has to be people that you really trust. They must be really trustworthy, isn't it, church? Yeah, because what happened is that for the law now to introduce that new office of enforcer is because how the law develops, it's when it discovers a lot of mischiefs, something comes up to take care of a mischief like that one. Most trustees have really run down trusts that have been left in their hands. And like that one, what he did, he reached a point, there were two of them, and they conspired, and they stole most of the properties that were left because the children were not of age. So by the time they were turning 18 and they had capacity to contract a lawyer to do things for them, by then, and now the work of reversing that and getting him back, the amount of pain that the family can experience because what you have worked so hard for ends up not counting for anything because everyone else benefits except the beneficiaries of the trust who are your children. So it is something that you need to really consult about, to really consult properly about so that you are advised properly. So I'll go back to Brian. There's an angle that we haven't covered of wills. We have talked about them peripherally and indirectly, but now we want to talk about wills a bit, will making, what goes into wills and all that, so that in case some of you have written wills, you are allowed to revise. Are we together? How to revise your wills? How are wills registered? Who are the parties to a will? What can you will away? And what can't you will away? What can you bequeath? And what can... Sister Nelly, in the list of properties in our will, we will classify shoes as personal effects and clothes. So it's not... I don't know if people can fight about clothes left behind by a deceased. So we'll let Brian talk about that a bit, then we'll come back to... I once did a will that was very interesting. I had clients who are Briton, and they are very interesting. And part of what they were writing in the will was how they wanted their bodies treated. You will talk about property. And one was donating to for research and all that. Another one said that he should be cremated, and the words he used were very interesting. And the ash in the urn will be thrown into a fast-flowing river so that his life is passed down to other generations symbolically. And he said, to sprinkle my ashes wherever, howsoever, and to go wherever, something like that, and it was very interesting. So what is willable and what is not willable is what Brian will handle in a few minutes, then we are coming back to you.
Okay, thank you once again. As I begin to tackle the question about wills, let me mention one point on the tax perspective. Family trusts are exempt from taxation but the exemption is not automatic. If you want a family trust, you must apply to the commissioner, and they must be satisfied that it is actually a family trust. Then they'll issue you with what we call an exemption certificate, which you will keep, so that anytime someone comes and tries to give you tax liabilities, you will tell them that you are exempt and you have a certificate to prove it. That is very important. Wills. What is a will? A will is a legal document which has the declarations of a person's wishes or intentions on how his property will be distributed or used upon his demise. And wills also include what we call codicils. Now, the next definition is codicils. What is a codicil? A codicil is also a legal document which alters, explains, or varies the contents of a will. And a codicil is, sometimes you make a will and you want to change something that was inside or was included in the will. So instead of having to alter your will every time and make crosses and making it untidy, you can just write in a separate document a variation of what you had said earlier. That is called a codicil. So who is supposed to make a will? A will is supposed to be made by any person who owns property. But then this person must be of sound mind, and it must be someone who is of age. So that brings me to what we call capacity in legal terms. But capacity basically means that you're of age and you have sound mind. You are having the ability to appreciate or understand the process of making a will. You can remember everything that you own, and you can remember also who is supposed to inherit the property, and you have, you understand the legal requirements, of who's supposed to be going into a will, and what's supposed to be included, who's supposed to inherit, and all that stuff. So, in his question, he asked, what can we include in the will? Is your property, including personal property, your personal effects, household effects. It could be real estate property. It could be shares, it could be free property, movable property, like your car, all that. But then there's a class of property that cannot be included in the will. And this includes property that is jointly held. If you are joint owners of a piece of property and you want to include this property in a will, probably you may not do that. Because joint owners have something called survivorship, where if anyone dies among the two joint owners, then the surviving person, the surviving party, inherits everything. So he absolutely owns everything that remains in that joint arrangement. So joint property cannot be put or included in a will. Another thing is nominations. Like maybe you own property in a pension scheme or in a SACCO, and you nominate someone who is supposed to benefit from your savings or your inheritance or your property that you own in that particular pension scheme. Then you cannot include that in your will because you already have a separate law that deals with how that property that is nominated is dealt with. And there's another class I'm forgetting. There are 3 classes of property that cannot be. There's nominations, there's joint property, then donations in motives. If you have donations that are made in contribution of death, say for instance that this person, the owner of the property, felt like he was about to die, and he decides to give property that holds title to that, like he gives away the title, document, or anything that shows possession of the property to someone else. So maybe, say he had a car, and he's contemplating death, so he decides to take the car keys and the logbook and all the car documents and gives them to someone and say, keep this, in case I die, you will have it. Okay? Then you cannot take that back and include it in a will as you're writing one. That now will not be included in the will. But of course, you must recognize again that if it so happens, yeah, that this person dies by suicide, the testator, the person who is making the property or making the will dies by suicide, then any gift that is given in contemplation of death fails. You cannot inherit property if the person who gave you that property or gave you that donation dies by suicide. So it will fail. And of course, you can also not inherit property after killing the person who gave you the property. So you cannot be a beneficiary of the murder. So I advise you to go and encourage people to write wills, then you kill them so that you inherit the property first.
In fact, that's why it's such a big secret. Huh?
Yeah.
So many of these things are only known to lawyers.
Yes.
Because depending on how many prodigal sons you have in the family, you write a will and they know that you've written a will, they finish you. But as it talks about joint nini that you cannot will away, there is also in law something called ownership in common. You can also just explain it, because in law there is a difference between ownership in common and joint ownership. Joint ownership is when your shares or ownership is not severable. It is one. You just present a death certificate and you inherit everything under joint ownership. But ownership in common is when your shares are clear and severable, like you have shares in a company, or your share in that property is distinct and clear. So it means the person who is supposed to inherit through me can only take that share under common ownership that is clear and distinct and that belongs to me.
Yes, thank you for clarifying that. So we were saying, we have said who can make a will. We have talked about what can be put into the will. Now, let me talk about now what makes a valid will. What makes a valid will? Not all wills are valid. There are certain requirements that that will must meet before it can be considered to be a valid will. Now, let me talk about written wills first. And in Kenya, of course, there are 3 types of wills. 2 are most common. There's one that is unique to those in military service. It's called privileged wills. We will see how that plays out. Written wills, of course, must be in writing the first. It must be in writing. The second thing is that that will must be signed by the testator. So he can sign or affix his thumbprint to that will. That is called execution. And then there is something called attestation, where there must be at least 2 competent witnesses. And if you are cautious enough, you will include 2 competent and independent witnesses, and I will explain the difference. We have competent witnesses and we have independent witnesses. A competent witness is someone who has the capacity, is of age, he has sound mind. Okay? But an independent witness is, on top of being of age and of sound mind, he has got no interest in that estate. Okay? He's not a beneficiary. If you have a beneficiary or someone who has an interest in the estate signing that will, then what we will do is, if he has an interest and there are only 2 witnesses who sign that will and is one of the beneficiaries, his portion of inheritance in that estate will devolve to intestacy. He will now consider it as part of what was not bequeathed under the will. He will lose his part of, he will lose his property in that will. Okay? So if you sign, as a beneficiary, if you sign the estate of your parent or anyone who is bequeathing you property, ensure that you have 2 additional persons who have got no interest in that will. That is what we call independent witnesses. Because if you don't, then we will say the will is okay, but you who signed that will and is a beneficiary will lose your portion of that inheritance. So those are 2 things. Writing should be properly signed or have a thumbprint, and then it should be properly signed by 2 independent witnesses who are also competent. And these 2 witnesses must have seen the testator himself sign that will or affix his thumbprint to that will. Okay? So that those 3 points are very clear. Now we have oral wills, where someone, instead of writing, he decides to speak verbally to his dependents.
Kwa deathbed.
Yes. Yeah. So he speaks to people, he speaks to, those he speaks out what his wish is about how his property should be used. So there also need to be 2 witnesses, and this person should die within 3 months after he makes the oral will. Okay? So it's valid for 3 months.
Valid for 3 months. That's the other way of saying that oral will is valid for 3 months.
Yes. So those are three very important things that you need to consider. 2 actually. 3 months, you should die 3 months after making that oral will, and there should be 2 people, 2 witnesses.
You can also talk about the special will by the people in military,
yes,
or in the Navy,
yes,
and how they make wills while at sea and all that. You
yes,
can talk, yeah.
Yes. So that's now called privileged wills. So privileged wills are basically applies to those in active military service. Yeah. So you know sometimes how it works in the military, you don't have the time to gather 2 people and sign everything. So it happens, they're privileged in a way that you may have 1 witness, an officer of senior rank. That will suffice as a witness. So even if it's 1 witness who was there when you were talking about, we were saying how your property should be used, that will qualify, or that will be privileged. That's why it's called privilege. It will be given the benefit of being a valid will, regardless of not having 2 independent witnesses to listen or have to witness how you want your property to be bequeathed.
But yes, as soon as it's back to normal circumstances, then he should be able to make a more proper will.
Yes.
Yeah.
So that only applies when they are in active military service. They're out there. So if he's in the sea, he's out there in combat, and probably he mentions how he wants his property to be spent, then we don't have to follow the formal requirements of valid will. We can just say there was 1 person who had an officer of senior rank, the military had you say that, then that counts as a valid will, regardless of not having 2 witnesses to show that. Yes.
Thank you very much. You have something burning? We want to take it back to you, but one of also the most important things on wills is the intention of the testator must be very clear. So, suppose some of the requirements were not really fulfilled, at least the words should be able to communicate clearly the intention of the testator, clearly enough for the will to be interpreted, to be, in law we say constructed. Construction in law means interpretation. It does not mean like an engineer construction. All right.
What 2 things?
Yeah.
Just
1 or 2 minutes, and
yes,
then we go to the floor.
I can see time is not on our side, but wills is a very big topic. So let me talk about 2 things about wills. One is if you want to change your will or alter your will, or you want to destroy your will. So when you want to change your will, as we've said, you can use a codicil. Yeah? And it could change because probably you have married, you made your will when you were still young, and we still insist and advise, not insist, but advise that as early as possible, don't wait until you become a billionaire to write a will. Start as early as you can and write a will. So if at all at some point in time you have probably remarried, marriage has a marriage changes, in a significant way how property devolves for a person. So if you marry, then you will need to make another will because it will change how you will develop property. This about destruction. Maybe you want to pass the property through will again, and sometimes you want to destroy the will. Most people sometimes decide when they're angered to just smash that will and throw it in a trash can and then forget about it. But in the past, we've had cases where those happen, and then probably the house manager, as you call them today, picked that up, kept it somewhere safe, and then when you die, the will is produced. They just unwrap the will, and the court says it's valid, and that's how your property is distributed. So ensure that you properly destroy. Destruction, it means that you burn it up. Like there must be actual destruction, and you must have the intention to destroy it. Yeah. So don't just even just shred and then leave it somewhere that someone can pick it, because there was a case where someone did the shredding, but then the beneficiaries were so diligent, they pieced back everything from the shredder, and they read out all that was in the will, and that is how the property was devolved. So you must always ensure that there is actual destruction, and you must actually have the intention to destroy that property, that will that you have. Yes.
Thank you very much. These are things that have taken us many years to learn. We probably can't explain them sufficiently enough in an afternoon, but we have tried to say that which is very important. And this is just one aspect, a small aspect of the law. Otherwise, it's a minds and minds of knowledge. Now, we now want to take it to the congregation, pick out the first three questions. Joy is one, another hand. Nelly. Hawa watu ni wale wanakaribia miaka 50 ndio wanauliza hii maswali. Who else? Towet, hauna swali? Ama most of your property is ancestral. On a light note. Go ahead, Joy Koech. And for purposes of clarity, we also have lawyers in the congregation. They are also second resource persons in addition to the panelists we have here. Go ahead, Joy.
Thank you. Thank you so much for a very engaging and useful conversation. I want to probably ask two questions. One is in regard to wills, something we've seen happening around. Can one dictate how the conditions beneficiaries must meet when they inherit their share? Like, for example, I've seen wills where people write that, you know, it's for the daughter, but when she gets married, she shouldn't share it with her husband. Things like that. So then the other one is in regard to trusts. Are there certain mandates that trustees have over the property in trust? Can they agree to sell it together? I've had also issues where kids couldn't do anything about a property because it's held in trust. If there's a little bit of clarity there, that would help. And also, I don't think you went into, you know, too much detail in regard to how trusts are formed and what trusts really are, like you did with the will. So I think I would appreciate a bit more detail on that. Thank you.
Yeah, so those questions are very clear. Nelly, then we will answer them together because you might find that they are related.
Thank you so much, Elder, for this very useful session. On the issue of trust, I just wanted clarity as to whether trusts only apply to commercial properties, like a company or business you're running, or even just private properties like a house, land. And then, you know, the way we know that wills come to effect when the testator dies, and the beneficiaries don't necessarily have to know about the will. They can know when the testator dies and now the will needs to be applied. How about trusts? Like, I have a company, I've appointed trustees. Shouldn't my children know, my family know who are the trustees of the estate? And if the trustees know and I've informed them, how about the children? The reason why I'm asking that question is the danger of when you have trustees with underage children who do not know anything about the business, the risk that you run, these children losing that property because they didn't know. So does the law also bar the testator? I don't know what the person who entrusts his property, I don't know what they're called, estater. So does the law also bar that person from declaring what this property, whatever commercial or private, is that he has entrusted to a group of people to run on behalf of the children?
Thank you very much. How is a trust formed? Do you want to start there? Then we go to wills so that you answer wills together and trusts together. Are there any hands up again? Could we reserve for the next set, if you can remember your questions? You know, sometimes you can forget your question. So make sure you remember them so that we answer in sets. Let's go.
Yeah, my apologies for not going into that, but I'll say first, a trust is formed through what we call a trust deed. But first, before you go to that, you'll be able to have identified who are your trustees to be. And your trustees to be needs to be, I'll say, using the words of my colleague, have to be competent individuals of sound mind, and if they are body corporates, they have to have that legal recognition as body corporates. Because you can appoint a trustee, but it can be a trustee which is a body corporate. You are entrusting them to run the affairs of your company. It can be a body corporate. Once you've done this, the document will be, you'll be coming up with what we call a trust deed. A trust deed entails or narrates what you want these trustees to do, what their responsibilities will be, and what their mandate will be. Once this document is drafted, the document needs to be executed by the settlor, who is the person setting up the trust, and the trustees who are being appointed, as a way of accepting their mandate to be appointed as trustees. Upon the document being executed, you might decide, because we have trusts that are not registered, we have trusts that are registered. Once, if you want the trust to gain what we call the legal person to be able to own property and to be sued, then you will go through the process of registration. The registration process goes through the lands registry, through the document registry system. The trust deed will be registered, and then once that is registered, then you'll be registering the trust deed for it to gain the body corporate status. For it to be able now, for you to be able to own property, it can be sued in its own individual capacity as a trust. Then the formation of, ideally, that is ideally the formation, but even as I speak of it, you need to also, the property that you are putting under these trusts to manage, you need to have control over this property. You cannot be giving property to be controlled by your trustees when you do not have ownership or you do not have control over that property. So you, even as you create this trust, you have to be able to ensure that any property that goes to be managed under the trust is a property that you own and you have control over. In terms, I think I've mentioned about the formation, then the question, I'll coin it together to our question, where she was asking whether the trust, is it, is it only for commercial purposes? I'll say no. The trust can have private properties. You can be a person who does not have a business, and you only have properties, you only have homes, or, you know, it's not for commercial purposes. But what you're trying to ensure is your children are underage. Who are the beneficiaries? Because there's a difference between trustees and beneficiaries. Trustees are the ones entrusted to run or to maintain the properties during your lifetime and even after your demise. The beneficiaries can be of age or underage, but trustees must be of age for them to be able to be entrusted with that responsibility of being trustees. These are people, for you to be appointed as a trustee, you must be of age, of sound mind, what we refer to as capacity. You must have the capacity to contract, because you're entering into a contract of trusteeship, which you are going to be a trustee. Now, when this is done, then the question you ask about trustees, the trustees manage the properties for the benefit of the beneficiaries. So here you have trustees must be of age, and this I needed to clarify to you. Trustees must be of age and must be of sound mind. They must have capacity to enter any form of contract. Once that is said, I think trustees, that's not only cover businesses, but it also covers personal properties, which where you have homes and you want your children to inherit, but they're not of age. Then you put the property in the trust. When they are of age, you can actually state and say that once my children are of age, this property needs to be transferred to them. That you can create it under the trust deed. You're giving clear directive on how the property should pass on. It actually acts in form of a will, in that you can actually instruct the trustees that my children getting of age, I want property A, B, C, D to move to them. The trustees will act on those instructions and pass over the property to them. And the other thing about, in terms of, on the trustees, there's a question you raised about, can they conspire and sell property. You mentioned about informing the children. It's important that they are made aware. This information should be shared, that I've appointed trustees. The only thing is that unless your children are of age, in terms of changing trustees, more particularly for a living trust, unless a vacancy arises or someone resigned from being a trustee or dies, that's the only time the children can come together as beneficiaries and appoint another trustee. But if the trustees are still in office and nothing has happened, for them to decide that they want to change those trustees, it will involve a court process. They have to prove that these trustees have mismanaged the estate, and they have, for them to be able to have the trustees removed. I'll touch on, it's a public case, so there's no, like now, one of the trusts that we have seen where changes like that have happened is the Njenga Karume Trust. You notice that of late, when the trustees, there was allegations of mismanagement, the beneficiaries moved to court, and the court was able to remove the trustees and replace them with new trustees. So the remedy for the children as well, in case there's mismanagement, then the children can move to court and persuade the court to remove them and replace them with the new trustees. The other thing on that as well is the new concept that has been brought on board, the enforcer, who is an independent party overseeing the activities of the trustees or holding accountable the trustees who are managing the estate. It's a very new concept in Kenya, and I think across the region, even in East Africa. So it's a very new concept about the enforcer, but this enforcer is ideally holding the trustees accountable for them to perform their mandate as per the trust deed, so that to ensure that there's no wastage of the estate in any way. I think that what I could have covered on the trust. If there's anything I've missed out.
Ladies and gentlemen, we only have 10 minutes to 4, and at 4 I know the other council is starting. We are supposed to have finished by now. But maybe next time, or even in the course of your response, you can talk about shortly, the duties and powers of trustees, because some questions are arising out of that, because to what, a trust is not like a transfer. You're not transferring what you own to another person. You're putting someone just to be in charge of those, to manage for the benefit of those that you work hard for. Yeah? Yeah. So wills and the trusts, the main difference is a will takes effect, as he read even in the Bible. A will takes effect when? When the testator is what? Is dead. But a living trust means you have opportunity to be able to watch and actually train and see what these beneficiaries are doing when you are still alive, and so that when you are dead or when you are gone, you know that you have left your things in safe hands because you witnessed them. Right? Yes, Nelly, quickly. Then we have 2 other sets.
Quick one.
Yes.
What happens?
There's a mic there.
Oh, thank you. What happens if the settler, I think, the person who entrusts,
settler,
God forbid, but the settler, he's done, entrusted, and everything is clear, the settler and the trustees perish, God forbid. Plane crash, anything can happen. What happens in such a case? They all perish at the same time. They shouldn't be in the same plane?
I know Dorcas is answering from a management perspective, that they can't all be in the same plane. But legally, the law provides and knows all those scenarios. Do you want to that quickly, and then we move to? Yes, we are coming to you, Elder. Did you want to?
Okay. Before we answer, she had a question as well. Can you dictate how the property is used? Like maybe the child can have, but not the husband. That was a question.
Yeah.
Well, as long as the property is within the trust, then okay. If it's a will A will, anyone who can take property through a will is a dependent. So if it's your daughter, when the property is in her name now, before marriage, it is her property. But once she's married and the man contributes, maybe it's a land that you gave your daughter and the man builds a house on the land, then it now becomes what you call matrimonial property, and that now both of them have an interest. So before, if the man doesn't improve the property in any way or does anything on it, then that doesn't qualify as matrimonial property. But if the man does an improvement and makes it now become matrimonial property, then now that one, both of them have an interest.
Say spouse so that usionee wanaume.
Okay, so the spouse.
Yeah, a short clarification from our panelists, then we move.
Just quickly to respond to her, I think there's something she said, can you give conditions in terms of who qualifies to get your property? As long as someone is your dependent and is biologically related to you, you cannot be seen to sideline them. We have seen cases where a parent, for one reason or the other, liked the other child and didn't like the other, and forms a will and gives 75% of the estate to one child and 15% to the other child. That has been reasons to invalidate the will, because it will be considered you have not adequately provided for the other child. So you cannot, there are certain conditions you cannot attach to. That's why even when you see, even when other children who come to claim from the estate, the only thing they need to, you always see being asked, let DNA be performed, then once we ascertain that this child is biologically related to this person, they can be able to benefit from the estate. In terms of putting those adverse conditions for before the child can inherit, no.
In case of suicide, someone is asking, then who gets the inheritance? I hope they are not planning anything funny. Do you want to answer that, Brian? Because you are the one who said, in case of suicide, you can answer.
Suicide only becomes a challenge if you donated property in contemplation of death, and then you die by suicide, then that donation fails. So, but of course, when you die, if you have a will, then we talk about the property now falls under the will. If there is no will, then we use the rules of intestacy. Suicide only becomes, you have something, senior?
Remember also, if you kill someone, you get disqualified. Yes, Sam? You want to contribute quickly, so because we have sets of questions there, and then we finish.
I want to contribute on the issue that Joy asked about conditional wills. What I understood about what she said, I want to get from an analogy from a will that I was handling some years back. And it was interesting that the maker of the will was their father. Say that he had four properties, and then he gave equally the three of them. And the fourth one, he said that I give it to my firstborn in case he takes care of me until I die. But if she doesn't take care of me, then it's divided equally between the four. That one can apply. If she doesn't take care of them, it's going to be divided. But he will give it as an extra because he wants to be taken care of, and it will be a reward as a result. Yes.
All right. Yes? All right, Elder, I can see Elder Odondi. Who else did I see? Their hand? Your hand there? I can't see properly. The bespectacled man. Yes, the bespectacled brother. That speaker above you, you have to move away. Move to the front a bit.
Okay. It's okay. Thank you so much. So number one.
Elder, stand next to the piano.
Okay.
So
number one is about putting your marriage in order. Would you consider mass wedding as a way of putting your marriage in order? Okay. That's something I want to request. Okay. Number two, what is the place of next of kin? Can my pastor or elder be next of kin? And then number three, records of property. Who should keep records of property? Or who should administer records of property? Thank you.
Thank you. You know, Elder Dondi is a lawyer in a sense. Huh? He has worked in court for long as a probation officer.
Thank you so much, panel. I think one of the panelists answered my question. I wanted to ask because, you know, our society right now is very polarized, and people actually die, testate, but they don't leave anything to all the dependents. So I think Grace answered my question, that the will might be invalidated because of that reason. So yeah, that's what I wanted to ask. Thank you.
And in fact, just to say another thing as you go back to see it is that as much as you are a testator and you have power to make a will, there are some overriding conditions which we don't have time to go into. There are certain types of will. For example, unfairness. If it's manifestly unfair, you, as some was saying, you have 5 children and you make a will, willing away property to only 3 of them, and the other ones you say, I don't even like them. Your will will be contested. So these are grounds for contestations of wills in court. Brian, do you want to answer that quickly, what Elder Odondi is asking? Then we only have 1 minute.
Okay, let me ask, mass wedding, should we consider having a mass wedding to regularize our marriages? That will be advisable. Yes.
Yes. Or thank you for that suggestion. I think it doesn't call really for an answer. You are saying that we should plan. Yes. I get you. So Sam?
I think we should.
And the head of department? Yes. He's saying that before Mashujaa Day. But tying it up with what we are dealing with, in terms of, you had us say that at some point, that situationships, you had that? And you're in something for so long and it's not clearly defined or recognized by the law, and then we start fighting as to whether the property that was left, is it really matrimonial? Then are you entitled to any portion of it? And you had recently the ruling from the Supreme Court. You had the ruling, ladies and gentlemen? Religious liberties. Can you summarize that in bullet point form and post it in all the church WhatsApp groups? Because we do have a big, it's like a departure from the past. The jurisprudence has been before that generally, if you prove contribution, even if it's indirect, you will be there for, as they said, if a wife takes care of a man so that the man gets free time to be able to go and work and peace of mind as the lady takes care of the children and the home, she has contributed very much, because the man now has peace of mind and a chance to be able to make money and buy those properties. So the lady is an indirect contributor. But now, the Supreme Court is saying what you came with, do what? Go away with. So in other words, so what is really the purpose of marriage, and what happens to the efforts that spouses have been making in marriage? Because even a man can contribute. Maybe if he's a stay-home dad and he's the one doing all sorts of things so that the woman can circumnavigate the universe and work. Maybe her work involves a lot of traveling. So what happens? So in answer to generally what you are saying, so that if the children of the world should not be wiser than the children of God, we should formalize our things so that it's very clear. And after formalizing, I think it's very important, even if the court ruled like that, just to say, it is very important to now be clear about, yeah, we are married, how are we treating our property? Because if we enter an agreement to that effect, even a court order or a court ruling cannot override what you agree between the two of you. Still, you are the strongest parties in an agreement. Would you say amen? Okay. Brian?
Yes, so as Senior has correctly put it, if there are parties in this church that have not formalized their marriages, it's very advisable that you can have mass weddings so that you register your marriages and it is recognized in law, so that you avoid cases of the court saying there is no marriage between you. The second one was, who should keep records of property? It's the owner. So the person in whose name the property is registered. So if it's a car and you have your name registered on it, it's good that you have a list of that. Because when you are finally now transferring it, making a will, or you are creating a family trust, you need to properly have a recollection of everything you own so that you properly include everything that you own in the will or the family trust. Yes. Yes? Yeah. Okay, so as you write your will, you should include someone we call an executor. An executor is a person who will now implement the will that you are writing. So it's always advisable that as you are preparing the will, you mention that person A will take charge of my property and he will administer my estate. So can be your son, can be your daughter, someone you trust. Yes.
Here is what I want to do as we wrap up. Minor, the last person, then we move.
Thank you, Elder. Question that I want to ask is, you mentioned early on about how you have, for example, Indian families who are able to see the benefit of this, not just for this generation, but generations to come. Whereas others, and Africans, I would say, mnataka nikufe nyinyi. Oh. So how do we address that as...
A quick keyword is what he was presenting, that trust, live in trust, give you a chance to be able to, because what she's really presenting is under general estate management, estate planning management. So it's by planning. It's by really planning. Now, I want to, in conclusion, and they are going to, what I want to ask them to say, they will indirectly answer your question. So here is what I want us to do. I'll give each of our panelists 2 minutes to say in a nutshell, here is what because I don't want them just to say anything, but here is what I want them to say. What is it in 1, 2, 3, 4 that this congregation, on the strength of what you are presenting, should do so that we are safe? Okay. I start with my sister.
First, on family trusts, I'll say that as soon as you have a bit of property, ensure that you have a family trust, or if it's a business, start introducing your children and let the children learn the mode of doing business. Above all, when you are appointing trustees to your business, ensure that trustees to the family trust, ensure it's people that you trust, and you also have a recollection of all your assets that are under your control or your ownership. Thank you.
As one other question I'll ask you so that you clarify. Now, as Elder Dondi has asked something that has gotten me thinking about who keeps records of properties. That is one segment, but the other one is, where should you keep your titles and everything and all that?
I'll answer that in twofold. There's ways you can keep your records. You can have an entrusted party who can be able to maintain a parallel record of what you have, so that there's someone else who is aware of what you own. In case of sudden demise, like Elder Donda said, then there's someone who is aware of what you own. The other thing we have seen is clients entrusting such a kind of documentation with their advocates, who maintain them in safe custody. If it's original titles, they are actually left with the advocate, but there's a trail to show that these documents have been kept in a certain office, or someone is in control or is holding these documents. So those are two ways you can keep them. You can either have your advocates keep them, or keep them, but have someone else be aware, someone you trust be aware of what you own and where the necessary documents are kept.
Something else I want to just tell the congregation. When you have an advocate who is a sole proprietor, you know from, if Dorcas will advise you about BCP, Business Continuity Plan, if that sole proprietor practitioner dies, all lawyers, we fill forms in Law Society that show which other law firm will take over my files in case. Yeah, so ask your lawyer which other lawyer is your alternative in that respect. You know, I'm saying these things because they are important. I've seen the benefit of practicing for a long time. I've seen these things. Huh? You see, I had a lawyer guy who was selling property to a certain friend of mine. And the Mzee had like 50 titles and originals, and he's walking with a bag in town every day with all his titles in the bag. If you see how sensitive he is about the bag, If you just even move your hand trying to touch the bag, the man looks very, very ferocious. Huh? So there is no need of doing that. We have solutions for such things, and that's why we have these professional conversations. Tumeona mengi. All right, Brian.
My two takeaways is, number one, write wills. From today, go and start practicing. Write drafts. It's good to have an advocate review, but anyone who is of age has the, in fact, even young people can make wills, but now it becomes effective once you're of age. So go and start writing wills tonight. Second thing is that if you're establishing family trusts, I'm not saying you go and die, I'm just saying go and write wills. Second thing is that when you have family trust, ensure that you apply for KRA exemption certificates. It's not automatic. It will be problematic when they find that you got some good money in there and there is no exemption. They'll charge you tax as they wish. So apply for exemption, have that certificate, display it in your place of business, and keep it anytime they come. You show them that you have the certificate of exemption. It will be helpful. So thank you so much, and that's all.
Alex, one of the reasons also the Asian communities keep wealth within themselves for a long time is the benefits they get from tax exemptions for family trusts. Because as he said, any property above, even it's below 10 million and 0 to 10 million, you get total exemption. If it's 10 million plus one, or so whatever is over and above the 10 million is what you are taxed on. So you still get a big relief. Ladies and gentlemen, that's all we had today. And what the religious, let me say that on their behalf, I'm not in that department, but an elder is an elder of the church. They are planning that apart from camp meeting clinic, we could have some of these things on some Sundays of the year. Instead of waiting until you have one Sabbath in the year to say some of these things, because we interact with the law every day without knowing it. Did you know that when you enter into a matatu, that's a contract? Yeah? It's an oral contract. They have, when you pay fare, you're paid consideration, and they have a duty to get you to town. You can sue them if they don't get you to town, and so many things. So that's all we could do for today, but they are going to give us a list of their activities soon, and we shall plan together. I'm in that council, and others, and we want to roll out something that can be of benefit to church in ways that may be, that are more elaborate than before, because we go as we learn, we should pass this benefit to the church, isn't it? Amen. Ni wangapi wanasema tumeshukuru sana because of our panelists today for what they have. Did you know that you have such a brain in your church? You can put your hands together for them. Did you guys know that you have such a brain in your church? Until today, until you give these young people an opportunity, is when you get to know that you are surrounded with very good counsel around you. All the way from Lavington, my little sister. Shall we appreciate this sister of mine for a job well done? For me, I have started feeling that old feeling of children that you've seen grow and now sitting side by side with you and doing a good job. I am the proudest of all. So I want to invite the leader, Mrs. Ondari, to come and say something thanking these guys, and invite your elder to also come and pray so that we finish this session. Asanteni sana for staying with us and for keeping it here. I don't know if this camera is on, but this is Gloryland Church, the best church to be in.
Happy Sabbath, church. What do you say for that? So we are here, we are in church, so you can consult us anytime. As long as we are in church, we don't ask for fees. Okay? Yes, so feel free to approach any one of us I'm kindly asking the council members to stand up so that the church can see them. The Religious Liberty Council members. Yes. So, these are your people. Just make use of them. Make use of us. Yeah, if you have any legal questions, feel free to ask. We are here for you. Yes, and I also want to thank, you can sit down. I also want to thank the panelists. May God bless you. And our moderator, our elder, God bless you. And the congregation for attending, okay? We would have had this meeting and no one would have attended. So thank you very much. And may God bless you. Yes. So elder, you can come and pray.
I hope all of us have enjoyed and have learned something, one or two. And we thank God we shall be doing most. There is much that is coming very soon. And let's keep waiting upon the same. We have come to an end, and we thank you for everything. As you shall be disbursing, we disburse you with God's blessings. Let's pray. Our Father who art in heaven, thank you for this time and thank you for everything. Thank you because of the elaborate discussion that we have had. We know that you want your children to always be prepared and to always be able to put that which you have blessed them in the right perspective. Dear Father, we pray that you may bless us as we are living. You may bless us abundantly. For this our humble prayer in Jesus' name. Amen. Amen.
Softly and tenderly Jesus is calling, calling for you and for me. See on the portals he's waiting and
This year I choose to be a faithful steward. This year I choose to be a faithful steward.
Stewardship means the careful management of everything entrusted under one's care.
Do you know your talent? Do you know what purpose you are created for? You are created to serve God and to serve fellow men with your gifts and your talents.
Know ye not that your body is the temple of the Holy Ghost, which is in you, which ye have of God, and ye are not your own? For ye are bought with a price, therefore glorify God in your body and in your spirit, which are God.
There is a purpose and a season and a time for everything under the sun. Time is the universal standard that will be used in judging everyone under the sun. No one can say they were given less than 24 hours.
I will honor the Lord with all my substance and also with the first fruit of all my increase.
I choose to be a faithful steward of the Sabbath. Just as tithe is holy, so is it the Sabbath. God sanctified it and made it holy.
I purpose to be a good steward of my body. I pray you do.
I purposely choose to be a faithful steward of finances.
This year, I choose to use my talent to glorify God.
I choose to be a faithful steward of time.
I choose to be a faithful steward.
We choose to be faithful stewards.
I choose to be a faithful steward.
I choose to be a faithful steward.
My brother, what do you choose to be?
I choose to be a faithful steward.
I also choose to be a faithful steward.